Hello, I'm Chris Gilliland, President of William Douglas Management Company. Today we're going to discuss easements. A recorded land easement is a legally binding instrument which permits or restricts land use by the landowner and other parties who do not own the land in question. Easements that are restrictive can limit particular forms of development, such as building a home with a minimum amount of square footage, or limit other activities such as where a fence can be erected. Easements can be recorded on the deed either as permanent easements or as temporary easements. Temporary easements have to be filed with an expiration date. An example of a temporary easement would be for construction that would be completed by a certain date. All easements have to be for a specific purpose as well. There are two categories of easements: appurtenant easements and easements in gross. An easement appurtenant is an easement between two parties owning adjoining property. An example would be one landowner may have an easement allowing a neighboring landowner access to perform maintenance on a storm drain that services both properties. An easement in gross is an easement recorded only on one property and not any adjoining properties. An easement in gross is usually a utility or a municipality easement, which would allow utility or municipalities to install water lines, sewer lines, etc. on the particular property. While there are two categories of easements, there are various types of easements: utility, sidewalk, beach access, to name just a few. Well, it's self-evident what a utility or a sidewalk easement is, but our client associations deal with one type in particular: easement of access. Easements of access come up most often when a member's private property has to be crossed to maintain common property or common elements that are the association's responsibility to maintain.